I request Sujit Ghosh to come on stage.
Much more interactive than what is finally happening. There were supposed to be 2 or 3 other great learned speakers, but unfortunately for some reason we have none. And I was supposed to be the moderator, and I'm therefore left with no choice but to be the main speaker. So my apologies. The Supreme Court is holding, or rather has held, the National Law Day at Vigyan Bhavan, so many of the stellar speakers are missing for that reason. Be that as it may be, I'll try to do my job. We have about an hour. I don't think we'll take so much of time, given that I'm the only speaker, so I don't want to trouble you with my monologue beyond a point. So the topic, when I was selecting this topic, my thoughts were not on the judgment per se. Can someone just shut the door, please? Just shut the door. My thought was not on the judgment per se, because that judgment can be read by all. The judgment is available for all of you to read. But behind the judgment, there is a whole huge universe of jurisprudence, which our Constitution has thrown up, which our judiciary has thrown up. And what I'll intend to do is to map them out and bring it to your attention in terms of how the evolution has happened and where we stand. Not so much of archaic discussion, but more relevant to the current context that we have. The Aadhar judgment is all about the extent of judicial review. Aadhar judgment is also about the separation of power between the 3 wings of the government. Aadhar judgment is also, to my mind, about judicial discretion, of how much of discretion exists. Do the judges make law? Because nowhere in your Constitution, as you read, you will find right to privacy sitting there in any of the articles therein. So it's all about judicial discretion. Do the judges make law? And the Aadhar judgment is also about the normatives of what is liberty in our lives. If you remember the way the Constitution starts, it says, "We the people of India solemnly resolve to constitute India into a sovereign, socialist, secular, democratic republic, and to give unto ourselves justice, social, economic, and political, and liberty of thought, expression, belief, faith, and religion." So within this 10, 15 words that the preamble conceptualizes, there are 3 very important words which to my mind has always been the bedrock of our civil liberty. The first point is justice, social, economic, and political, and third is liberty of thought, expression, belief. The liberty is not about only what you want to express. Liberty is also about what you do not want to express, because expression comes along with it right to not say, right to not express. The second cognitive part of the preamble, which is very, very important, is liberty of what? Liberty of the citizenry, liberty of the people that we are. So the very context of privacy, a right to privacy, as it has evolved over the period of time, finds its mention, finds its thread from the very preamble that we have. And to top it up, Article 38 of the Constitution very clearly talks about, a directive principle for the state to ensure that there is economic justice, there is social justice, there is political justice. So you cannot read the Constitution in isolation. The Constitution needs to be read in the context of what the preamble envisaged, and also at the same time what the directive principles of state policies are. Because at the end of the day, much as we may say that DPSP or directive principles are not justiciable, but the Supreme Court has very clearly brought out in many judgments, including Maneka Gandhi's, where they say that no, DPSPs is as much justiciable so long as they are read along with Part 3 of the Constitution, which is our fundamental rights. So keep that context in mind on the one hand, and then let's just jog through how it has evolved. So the first thing is about the judicial discretion. In interpreting the articles of the Constitution, Article 21 to be precise, Article 20 subclause 3, Article 14, 19, whatever else you have, the first and foremost thing that has always begged the judiciary thus far, way back then, was where is right to privacy? Yes, you have a right to life, you have a right to equality, equal treatment before law, where is right to privacy? Now, what is important is this age-old debate between the textualists who read the Constitution, who read the Constitution as the Constitution reads, the textualists, versus those that have been reading the Constitution in a constructive manner or purposive construction. Worldwide, internationally, this has been a great debate, and not only about Indian Constitution, even about the American Constitution. So on the one hand, you had H.L.A. Hart, famous English jurist, professor, who would talk about the hard case concept. On the other hand, you had Dworkin, Ronald Dworkin, which was the American philosopher, who would speak about thus far and no further, judges only discover the law and that is what it is. So the whole debate between the textualist, which is the Dworkin's philosophy, and the contextual reading or the purposive reading, which is H.L.A. Hart's school of thought, was very, very emotive across the world. H.L.A. Hart's concept was all about there is always a hard case. Not every case is simple, not every case is simpliciter, because when it's coming before the highest court, the High Court, or the Supreme Court, as the case may be, there is always a hard case. And if you have a hard case, then you'd read the Constitution or you read the legislation in such a manner that you have two or more reasonable constructions coming out of the constitutional document or the legislative document, and then you make a choice between the two. If there are two or more reasonably correct interpretations available, then you choose one of them, and that therefore becomes the discretion that the judge uses to interpret that piece of document. Whereas on the other hand, the Dworkins of the world would say, no, there are precedents. Precedential evolution of law is what it is. The judge only discovers what has been there. And it's about time to also make a reference to Barak's statement. He was the judge of the Israeli court, Israeli Supreme Court, Aharon Barak. His statement was also very simple. He says that, look, if you don't give judges the discretion to interpret, then you are basically talking about mathematical analytics of the law, which is certainly not the job of a judge. Anybody can do that. So if there is a hard case, and at that point in time you have multiple options available to you, which are reasonable, then Barak also says that you must read the Constitution, read the document in such a manner that is able to subserve the purpose for which it has been evolved. So therefore, the whole construction of constitutional documents, legislative documents in the international arena, whether it is Israel, whether it is the United States, and for that matter, a bit of English law as well, comes about that judicial discretion or judicial reading of the law is fundamentally echoed in the very right that the judiciary has to dispense justice. And in keeping with that, what we often call, what Fali Nariman had called, was the silence of the Constitution. What the Constitution does not tell you is what the silence of the Constitution is. And therefore, your ability to read behind the scene, between the lines, behind the text, is what is called the silence of the Constitution to be read. And what this judgment does is no less than reading the silence of the Constitution to bring about right to privacy as a fundamental right. So that's very one important thing. At the other side of the arena is the whole concept of how much does the administrative authorities or the executive of the country play a role in this evolution? Because if you know, the entire Aadhar, which was a statute which came through the 2016 legislation, there was a whole host of executive action that was also happening. The executives were supposed to implement a bunch of things, whether it was to your Central Board of Schools, CBSE, and various other banks who were trying to do various things. There are lots of policy documentation that was happening which did not have the force of law. And in the legislative concept, we had the statute which was pretty much elected by the parliament, and therefore you had the other things. So therefore you had a legislative action and an executive action, both kind of flowing through. In the American context, a very interesting philosophy had evolved many years back, about 24 years back, and it continues to happen. In the context of judicial review, starting for Mallory versus Madison, if you ignore that, but you come back to the recent times, this is the judgment called the Chevron. It's called the Chevron Doctrine. Now, Chevron Doctrine is something, to my mind, has a significant bearing in reading executive actions in the context of legislative interpretation. What that judgment brought about was a new doctrine. What they said was, when the Congress comes out with the legislation and expects the executive to enact or to kind of implement it, then the judiciary will not intervene and second judge the executive. They went about to bring out this concept of executive discretion. If the executive discretion is met or is being exercised to subserve the purpose for which the Congress has brought out the law, then the judicial review cannot lie. And the case in hand in that case was all about environment, So if the Congress had come out with a policy or a statute to say that, okay, pollution in the country will have to be abated, it had to be reduced, and for that purposes, the executive will come out with appropriate policy document, administrative instructions, so on and so forth, then the means used by the executive to deliver that policy statement of a statutory nature, i.e. to emanate to kind of reduce the pollution in the country, judiciary cannot sit in judgment to say whether the executive had the power or not. Once that principle is there, discretion has to be exercised by the executive, that's it, thus far, no further. The Chevron doctrine went about, it evolved further up in two other judgments. One is the Maid Corporation and then Lopez judgment. So basically, the US is very clear about how much to intervene. Put it in the context of Indian situation. The principles of administrative law or executive action is very clear. If the source of power is not found, well, then the executive does not have any action. But what the Supreme Court said in the context of Aadhar was very, very interesting, and rightly so. It went about saying that, well, the executive is certainly empowered to do what it chooses to meet the policy statement, but executive instructions per se is not law, and therefore anything that is bereft of a legal status or legality is not there in terms of the law as we understand in the Constitution, executive cannot interfere. And therefore, all these KYC norms that came through from the banks to say that, okay, you need to link your Aadhar with a bank account and so on and so forth, kind of fell flat because they did not have the legal backing. So the contrasting jurisprudence from the Americas to the Indias is very, very starking to say that the purpose of Aadhar was, as the government of India put it up before the Supreme Court, was that, look, we need to make sure that the monies that the government wants to spend goes to the rightful people to whom we want to disburse. All the social functions that we are doing, whether it is PDS supplies, whether it is social services through the various economic benefit that we want to dole out, for that we need to be very clear who are these people to whom we are giving. So the purpose was very, very clear. And in actuating the purposes, the executive could have done a bunch of things, but the executive was debarred from doing so. So that, therefore, is a very, very interesting deviation. I would not say deviation. It's a separation, distinction between the American jurisprudence and what we have. So the context, therefore, is in reading the Constitution, what did the Supreme Court find? And there are 3-4 very interesting aspects, which I'll take another 5-7 minutes to close out on the topic. The first issue was about where is this right to privacy to be found? And then this is where the Supreme Court came out with a very fundamental concept. They said, look, you don't have to look at the Constitution to find this right to privacy. Liberty, dignity, right to live with dignity, inheres in it right to privacy. And right to dignity, right to liberty is something that our constitutional does not give us. It is basically fundamentally a natural law that we have imbibed. And with or without the Constitution, your right to live with dignity, which is fundamental to your existence as a human being, not as an animalistic pattern, that is what the language that they had used, is where the entire concept of privacy comes about. Now, they also went about looking at a bunch of decisions that were there. We don't have the time to go through. Only short point I want to make. The minority decision correction, for those of you who remember in your school days, minority decision of correction is what has become the majority decision here. Or the majority decision of correction has been overruled. Effectively, in correcting, the majority came to the conclusion that yes, nobody can just wake you up in the middle of the night and take you to the bar, to behind the bar. Okay, but then they said there is no right to privacy. So having come that far, they stopped short of saying that there is no right to privacy or there is a right to privacy. Minority says no, it is quite incoherent, because if you are not permitted to entrench into person's private space by coming into his house and taking or handcuff him, then by logic, it is necessary that right to privacy has to be read in. So that minority decision, which was brought out then, went on to become the majority decision here. So that's the first thing that comes out, that it is a natural right, and therefore right to live in dignity is what is fundamental, which doesn't come out of the Constitution. The second point that came about, which was a very interesting point, that look, you talk about your right to property, and digital property is as much a property, and therefore whatever protections that the law provides for your personal property has to be accorded in similar vein to digital property. That's a very new concept which hitherto in the past was never deliberated, and that was what was tendered before the Supreme Court. The third was very, very important, and this is what people have been saying, that 19(1)(g) talks about freedom of expression and so on and so forth, but where is this freedom of press coming from? There is no right called freedom of press. So if freedom of press can get read into right to freedom of expression, then equally speaking, right to privacy has got to get read into right to life, right to live with dignity, and so on and so forth. That was the assimilation. But in all this, what the Supreme Court brought about was three very important aspects. They said, look, fine, we understand. We appreciate the fact that this has to be given a fundamental right status. But then, like any other fundamental right, it will have to be subject to reasonable restrictions that are provided. Those restrictions can come through Article 14 or the reasonable restrictions that are being contemplated under 19. So they said there is no absolute right to privacy at all. And if there is any legislative intervention through which this right is sought to be taken, then they came out with what is called the three-pronged principles through which you will test them. And I'll just read out those principles. First, they said the legality aspect, which I spoke about, that there has to be a law through which you kind of indulge in curbing the freedom or restricting the freedom and so on and so forth. So if there's any executive action, sorry, you have no legs to stand. The second was the need philosophy. What is the government's need? Is there a need that the government has for which it is seeking to curb your privacy rights? And that need has to be very well defined, which has to be tested against the cornerstone of proportionality. And these two words, proportionality and need, is always going to be a subjective debate. There is no objective criteria to find out what was the government's need and was it a proportionate action, so to say. In other words, what they're saying was, if the rationale for which you are trying to curb the privacy rights, the means that has been used to achieve the rationale should be proportional. You cannot use disproportionate means to curb the freedom that the person has, and therefore the concept of proportionality has been read into it. Having said that, Justice Nariman made a very interesting observation as well. He did not rely on the Constitution as much. He went into the UN conventions that India has signed. Very way of reading the Constitution. The UN conventions of 1966, 1984, and the likes all talks about dignity of human being as a species, and what the countries need to do to achieve that kind of a dignity. And therefore, he said, look, once India has signed that charter, India is bound by that charter to make sure that human dignity is preserved in the most pristine form, and therefore you cannot say that your privacy does not exist. And Justice Chandrachud went one step further. He said that, look, privacy cannot be understood to mean privacy in your bedroom. When people are operating in public space, even then they need to be given privacy. And therefore, what you can publish, what you can't publish for the press, for people at large, what you can use as an information to defame or not defame, irrespective of whether it's a personal space or public space, that privacy has to be protected. And that is what was the germane point. Thank you very much. I think I've got a call that we need to stop. My apologies. We are making it a short session. Wish you a very good evening. Thank you.